Hi, everyone. Welcome to Reuters Events webinar called Proactive Claim Litigation Management, Combat Social Inflation, and the Sophisticated Plaintiff Bar. So welcome to this discussion. In today's challenging insurance landscape, as we know, social inflation and sophisticated plaintiff strategies are dramatically impacting claims outcomes. Recent cases demonstrate this stark reality. Actually, Dell will tell you more on this in a few moments. With something which could begin as a $25,000 claim could escalate to $7 million claims, highlighting the critical need for proactive claims management. Today, we are expecting 300 to 400 people on this conversation, but I want to also highlight that we will be diving into these topics in Orlando at Reuters Events Connecting Claims, which will take place in November this year, to address the urgency of this challenge within our industry. The other point I wanted to highlight is David will probably tell you that recent tort reforms in Georgia, for instance, in Florida in March 2023, challenges and reshape third-party litigation funding landscape, making it crucial for insurers to adapt their strategies. So I'm really, really thrilled to have four amazing speakers on this panel discussion. We have Dave Vanalek, Chief Legal Officer and Compliance Officer at Freeman National. We have Lynn Moretti, Senior Vice President and Head of International Claims Transformation at HamTrust International. Dale Diamond, Vice President Claims at the NIMIC. And Alan Kirst, Head of Claims Judicial Legislative Affairs at Zurich, North America. So we are thrilled to have you this morning, this afternoon, this evening, to actually tackle this amazing and really interesting topic around claims litigation management. And remember that this session is for you. So we are expecting you to share and participate to this conversation with a lot of questions. So let's start with our discussion with our first theme, which is about combating social inflation in claims litigation. And so David already mentioned some of the items we discussed when we were preparing for this discussion. So when we actually look at the recent tort reforms and how those reforms are actually helping insurers combat social inflation, what additional regulatory measures would you recommend for us to consider?
Yeah, that's a great question, Sabine, and welcome everyone on the line. Really excited to be able to share some thoughts on this particular topic. The topic of social inflation. When folks mention that particular term, just to kind of make sure we've kind of level set, the audience. What we're talking about is not normal CPI inflation, economic inflation, but what we're talking about is what would be kind of the reasonable customary increase in pricing seems to be exceeding that, which is, the normal customary measure of what would normally take place to kind of resolve. And this concept, goes back, I think Warren Buffett had a comment in a shareholder letter back in the late 70s, identifying, this particular concept. So it's been around for quite some time. But it really has amplified over the last several years in particular, especially with respect to some of the causes of social inflation and the increases in the matters to resolve. And there was a panel that Alan and I were on maybe a couple of months back where one of the gentlemen had mentioned legal system abuse is really maybe a better moniker at this point, or at least maybe kind of framing the discussion so that folks truly understand if you have legal system abuse that's taking place in the courts, what are those measures that can really help tackle the issue on a claim by claim basis. You asked about tort reforms. That from an industry perspective, I think is you're really starting to see a lot of traction in terms of tackling the issue of legal system abuse. through tort reform efforts. That is a long-term play that takes quite some time to get through each individual legislature. Even once it gets through the process, what's ultimately signed by the governor or may not be signed by the governor of a particular state becomes the law on the books. This particular year, you saw some pretty significant reforms take place in Georgia through SB 68 and SB 69. SB 68 was basically attempting to modify some of the practices in courtrooms, such as jury anchoring, identifying fairly high numbers to allow the jury to anchor around. They also reformed several measures around phantom damages, which is the ability to present medical bills before the jury. It's about half the states, about 25 states, allow juries to consider full phantom damages, which is not what was actually paid on the bills, but actually what was charged on the bills. And that tends to be a significantly larger number than what's ultimately required to pay off those medical bills. So you're seeing efforts underway in Georgia with respect to those particular issues. And then I would also say SB 69 was a major foray into creating some disclosure around what's called third-party litigation funding. I'm sure many of the panelists here can share with you stories of how third-party litigation funding in that particular industry has, in essence, created or made the judicial system an investment vehicle, basically, where I think the last number I saw was roughly 15.4 billion or so assets under management, where loans are being made to particular pieces of litigation. In return, if those results come back fairly significantly, there's a return on investment in those situations. So this has caught the eye of the federal government, multiple states. Georgia, as I mentioned, under SB 69, created some disclosure requirements around that. A few other states, I think Kansas recently created some exposure behind that. And all of this stems too from some significant tort reforms that took place in Florida about 2 years ago, back in March of 23, as you mentioned in your opening comments. And I think what you're seeing from that is actually a stabilization of the Florida insurance market at this point, as well as basically, I'd say a cresting or a stabilization of the number of lawsuits. I think one of the articles I was reading mentioned the percentage of suits have decreased about 24% over the last couple of years in the state. And it is all these different measures are designed to really try to create a more level playing field. So I welcome some of the comments of my fellow panelists on those points.
Yeah, absolutely. And as we are talking about claims, right, I'm going to come to Lean, right, and ask Lean, what are the most common self-inflicted errors within the claims handling process that exacerbate social inflation? And how can insurers, therefore, address this issue most proactively?
Well, I think David just led me in with the perfect segue about leveling the playing field. I mean, that's all we want, right? We want the scales of justice to level out and not have it favor one way or the other. However, I take a little bit of a different take. Why did we get there in the first place, right? So what's the self-assessment? I see a lot of unforced errors. I like sports analogies. We didn't lose this game because of the refs, right? We probably lost the game in the first quarter or maybe even in a training camp. Do we have the best team performing from protecting our insureds, providing the best legal advice, doing the proper evaluation as early on as possible, and early recognition? The game has changed. There is social inflation. That is a fact. There are difficult jurisdictions. That is a fact. We know that when the claim comes in. Are we evaluating it fairly, realistically? You mentioned the $25,000 claim that becomes $7 million. Neither value is the correct value for that claim. And there were probably points in the life of that claim where it could have been resolved for a fair and reasonable amount. Why did that not happen? Were the claim professionals trained appropriately? Did they have the confidence to bring difficult news to management? Did you have an engagement and empathy, the negotiation skills to work with the other side? Or did people dig in their heels unfairly? And so those are the types of points that I think when you look at the so-called nuclear verdicts, how many of those really were avoidable? There's going to be truly difficult verdicts, places that you cannot resolve a claim. We all know that. However, I do believe that with some good self-reflection and some better processes, better tools, education, training, we can avoid those unforced errors, those self-inflicted wounds on ourselves. I think that the number one cause is really a lack of attention on those attritional claims. You know, where can you really make a difference? We always run to that bright, shiny object, that big complex claim that comes in, but that may not develop as much as that smaller claim that just wasn't properly tended to. And that goes to that failure of early recognition, and that lack of a realistic evaluation and being able to understand what do you really need to resolve that claim, and not prolonging that claim to a point where it then can't be resolved.
Yeah, yeah. Which I guess led me to Dale, because you need to tell us a little bit more about this case, right, Dale? And how can actually a small insurer, particularly those in specific market segment, mitigate the impact of social inflation and nuclear verdicts? So please tell us a story and help us understand what we can do better.
Sure. Thanks, Sabine. And that's a great question, because with social inflation and these nuclear verdicts we're seeing, especially after the COVID crisis, a lot of the larger stock companies are more able to prepare for these, to educate their claims folks, to have training. And if the worst happens and they have one of these nuclear verdicts, they're better prepared to deal with it. They have counsel ready. They will get the post-trial motions going. They have appellate attorneys they can turn to try and get it overturned. They're just more sophisticated in general. So at the National Association of Mutual Insurance Companies, our association is working every day to try and make things better for smaller mutuals, even though we have mutuals of all sizes. Many of them are small. Many of them are farm mutuals throughout the US and Canada that really play a significant role in insuring farmers, insuring ranchers, insuring rural American and Canada for their property and casualty and their small business. And they're facing so many challenges right now. You have, in addition to what's going on in the legal market, you have the effects of climate change, which really impact these agricultural mutuals. And a lot of times they would think maybe they're more insulated. When you think of nuclear verdicts, when you're thinking of the cost of litigation, a lot of times you'll think it's more in the more urban areas, in the big cities, and what they call the judicial hellholes. But what's happened, especially since COVID, is trying cases anywhere is gotten very risky. So you may be in a more urban or exurban or suburban jurisdiction. That doesn't guarantee you're going to get a no liability finding. It doesn't guarantee you're even going to get a small verdict. So you mentioned before a case that I had brought up where when it originally came in, it was seen as basically a nuisance value case, an auto accident where someone had been driving down the road and a piece of a truck fell off and hit the car. Definitely clear liability, but the person driving was refused transportation to the hospital. Seemed like he had injured a wrist, and so it seemed in initial evaluation to be clear liability but small damages. As things progressed, and this goes back to what Lynn was saying, there were chances to settle. There was, the limits demand comes in on $1 million policy, but it was still seen by the claim handler as a small claim. A few things, like Lynn was also mentioning, it wasn't really round table. One person got it. They kind of put it in their nuisance value claims, didn't pay a lot of attention, and things just spiraled until it got past the point where it could be settled. The plaintiff was able to get an expert on board to say there's in fact a brain injury. There's a question about whether it hit the windshield or whether the windshield had broken from the object that hit it. And the claims person really got into the mindset that in her opinion, this is what it was. So it ended up going to trial without having a mock jury, without really too much preparation. And as you mentioned earlier, the jury came back with $7 million. And that was an excess verdict, and that's where we get involved as the bad faith insurer for these small companies. And again, for this company, unlike maybe a larger company, it was pretty devastating. They just don't have the wherewithal. That it affects their reinsurance, which is another challenge for these small companies. The cost of reinsurance keeps going up and up. And if you have one of these nuclear verdicts, it will affect your renewal very significantly. And it can be something that puts your company in jeopardy. So it's a whole different world for the smaller carriers trying to deal with the issues we're discussing today.
Thank you so much for this reply, Dale. And I'm getting questions. But before we go into questions, I would love to hear from Alan. And Alan, based on what you heard from Dale, what role does defense attorney, really plays within that environment? And partly when we think about social inflation, and how can an insurers like yourself better align with their legal partners to reduce excessive litigation costs?
Well, thank you for the question. Yes, I think you said it right there. Defense attorneys are really our key partners in combating social inflation. I'll say, David at the onset talked about the definition of social inflation, and I agree. It's the disproportionate increase we've seen in loss costs. He also mentioned the term legal system abuse. And this is a term that we've been hearing more in the last couple of years or so. And it's really an effort to get the general public to understand what the impact is to them. So the term social inflation didn't really resonate with the public, but legal system abuse talks about the legal system, right? So we're talking about litigation, and we're talking about abuses that occur. So defense attorneys are key in how we combat that. So ways we can do that, certainly critical information. The adjusters need that critical information sooner in the case. I think to Lynn's point, be honest, be objective about what you're seeing and about what you think about this case. One of the worst case scenarios is hearing that on the eve of trial and saying we have to settle. And I think that's the point that Lynn was making. I'm sure we knew that earlier on in the process. So let's be transparent about that. I think as defense-minded people, we do tend to fall in love with our case. So how do we look at this more objectively? What is the jury going to see? What is the jury going to hear? One of the reasons I like the term social inflation is because there's definitely a societal element to all of this, right? There's attitudes out there that are changing, an anti-corporate bias that's there. Younger jurors just view their role as a little different as some of the older jurors out there. So how are the defense attorneys going to address that? And when they look at the facts of the case, how do you think that's going to resonate with a jury? And by any of these comments, I'm not saying that we should, the reason to how to combat social inflation is to settle everything, right? Certainly not saying that at all. In fact, I'd venture to say we should probably try more cases, but let's make sure, number one, these are the right cases to try. And second, that we're fully prepared. And when I say that, I mean, don't just pick apart the plaintiff's case, which I think was sort of a traditional way of defending cases, but to have, your own story as the defense. The last thing I'll say is, in Sabine, you mentioned at the onset, the plaintiff's bar in all of this, right? The plaintiff's bar in this country is extremely well-funded, well-organized, well-coordinated, right? They share information. They're very good at it. We, on the defense side, traditionally, not so much. And that's clearly where we need to do a better job. And I think Dale made a reference to that as well. I do think it's getting much better, though. I think in the last couple of years, I know that we started what's called a Defense Attorney Summit. So getting our defense attorneys, our staff legal, as well as our panel firms together to talk about those strategies, to talk about what the plaintiff's bar is doing out there, and to share tactics and stories that work. So As a key partner, what we need from our defense attorneys is to share those stories, share that information, share it with us, share it with each other, and be more open to that, which I know we haven't done in the past. There are a few groups that I think are really doing a really good job of that. In addition to what we do at Zurich, the DRI has gotten much more involved. There's more content around social inflation, the various drivers. What do we do in response to that? CLM is another great organization that's out there that's putting out some really good content. So I do think we're getting much better at this, but we need to continue. We need to continue to share this information, share tactics, and really work together, because that's what the plaintiff's bar is doing.
I think it's very important to echo a few points you've just made here, Alan. It's the world is moving, right? We are shifting to a world which is more, I would say, a co-opetition world, where we collaborate with our competition and where we're actually building ecosystem which helps us actually answer the question faster by actually leveraging the knowledge of the many rather than the few. So we are going into actually probably addressing some of the question, Lynn, because we are going to talk about enhancing claims professional development. I had a question for you, which I think links very nicely with Ken's question to you, which is, how can insurer revitalize training programs to ensure claims professionals are equipped to handle complex litigation scenario effectively? And Ken was asking you, Lynn, how are you thinking of incorporating tools to upgrade your claims handlers to ensure it's non-prolonged?
Right. I mean, I think it is all of an investment in people, investment in tools, investment in that training. And, we say it, people, process, tools all the time, but really, what does that mean? And you can take a look at, I've been using this phrase for a couple of days now, which is short-term gain equals long-term pain. And, I think some of us, we scrimped a little bit on the training. There was some turnover. We've invested in just hiring laterals, and that those robust training programs that were, very much available back in the day are still there, but not as robust as they used to be. And what type of candidate are we hiring? Are we hiring that curious? Are we hiring that person that has that empathy? Do we give them the guidance and the protection to take a chance, right? A lot of this happens because people are fearful, right? As it was said on this panel, maybe we need to take more cases to trial, right? Maybe we need to try the right cases. And, sometimes a jury might need to tell us that is what the value is. And that might bring everybody to the table. The deep, keen jurisdictional knowledge, I think we've gotten a bit away from that. One of the best insights I had was a claims professional called me up. She was at trial. She saw how the jury was taking the case. She said, "It's not going the way we thought. I can see it. I heard it in a different way than the way we've all roundtabled it. Lynn, we need to resolve this case." And sure enough, she went in, we resolved it. And, the jury came back with something that we probably would be talking about right now, but we're not, because she was astute enough to see that it changed. Something changed. Some dynamic that we thought was going to come across didn't. But she was there. We invested in the time and effort for her to be there, and we respected her insight. We weren't second guessing. She's closest to it. That's who you rely on. And I think some of that we've moved away. I was part of the Coalition for Litigation Justice when it first started in the early 2000s, and we did get that benefit of tort reform, the industry coming together on common areas, and we did thwart the silica onslaught. And so that shows that coming together on key issues, we can level the playing field. We can introduce tools that benefit our claims professionals, and hire those people that really can have an incredible career as claims continues. I mean, they're not going away. We know that.
Yeah. And again, thank you very much for your question. And actually, your question is so relevant. We have built a literally a discussion which are going to address not only talent but technology. So Frank, give us a few moments to answer your question, because I'd like to come to David first, right? Around, when we start looking at strategies, following up what Lynn just said, we need to attract new talent. We need to retain top talent within our industry. So especially, in high stress environment, which is what we are talking about right now. So how do we do that?
Yeah, no, it's an excellent question. And yeah, to Lynn's earlier comment about, as an industry, we're generally kind of doing kind of lateral hires kind of within claim organizations. We really need to be thinking outside the, insurance industry, in particular, identifying those, professions that have, the skill sets, required to, allow one to, critically analyze, the claim and adjudicate it within a high stress environment. I know in one of my, prior lives, when I was, defense counsel and ultimately in a claim organization for about 14 years, there was a, fairly concerted effort to identify, folks in the legal profession in particular, attorneys who, again, being in a high stress, litigation environment, could understand that. But then to Lynn's point, having that deep jurisdictional expertise in particular locations, being able to identify which judges, which plaintiffs' attorneys, what have you, might be a bit challenging. All of that information is absolutely critical. And to Alan's point earlier, when he was describing having that better collaboration with the defense bar, I know there was also discussion involved. There was like a former plaintiff's attorney who was on my staff. So having that understanding as to what's the typical playbook that's taking place there, so that you're able to objectively not just look at plaintiff's case but also the defendant's case as well. And even today, with some of the different challenges taking place, you hear in the news, with the federal government and various layoffs and that sort of thing. I think there's probably great opportunity, with various departments there, investigators in particular, who may be looking for some opportunities in utilizing their skill set, again, in a high stress environment, because that's what they're used to, and pulling that over into this environment. So I think right now it's interesting. I think we're at an inflection point where we're perhaps maybe have some more opportunities than we've traditionally looked at as an industry.
Yeah, if I may go back as well,
Yeah.
though, on the AI issue, I think it does have a role in our future, and we're not properly leveraging it. And I think what's crystal clear is that it needs to be, there's a place for it, and it's not replacement. What it does is it allows us to be more intentional about our analysis, use those qualities, use those skills, and not be distracted by maybe the mound of information, but allow us to focus our attention on those areas that gets us to resolution. And David, to your point, sort of that crisis management, whether it's veterans, retired police officers, teachers. There's a wealth of individuals that I don't think we've properly leveraged that can come in and bring, resolution to difficult situations, which is what we do day in and day out. And dealing with tragedies. There's, the most difficult cases are the saddest cases. And I think everyone around this table has photographs in their head about different claims that have come across their desks that are just emotionally charged. We need to remember that, and that will get us, I think, to that point as well. Again, the game, it's not a game, right? This is life, and it's often death, but is to reduce the volume of cases that are being impacted by social inflation and reducing those unforced errors. So if we can do that by investment in our people, I think we're going to, again, that's when we're going to have maybe short-term pain, but long-term gain and turn it around.
Yeah, absolutely. As you were saying that, Lena, I was just literally flashing my head being on stage with one of the executives of Zurich, actually, with an emotionally charged claim situation, where Zurich put actually a video of that claims and how the claim handler dealt with that claims. I think we share this every year, actually. Alan around Christmas just to remind people of the power of insurance. And so that actually the claims handler are here to help people in stressful time. And it was a very simple claim, not litigation related, just an amazing claim handler dealing with a motor claim where the claimant actually was living in his car and did something amazing to help that claimant, was actually treated with respect and put back in his car without him realizing that the insurer knew what was going on. Dale, I would love for you to actually tell us what alternative talent pool we need to consider, right? We are still talking about talent. What are the things you've seen working in our industry?
Well, Sabine, this is a critical issue. I was just last week addressing a lawyers group down in Florida on this and a lot of other issues. And they told me that when they're dealing with claims people in claims departments around the country, they are amazed at the age. They do tend to be on the older side, the vast majority. They said it's not usual to be working with a younger person in these claims. So I did thank them for letting me know that at 66, I was on the younger end of the claim handling spectrum. But all kidding aside, it's a serious issue because these people are going to retire, and it's a real challenge to get the replacements in and get people. And I know a lot of the universities now have very good insurance schools, throughout the United States and throughout, a lot of countries. And one of the young men that works with me came out of one of those programs, but he said he was literally the only person in a class of probably 100 who had an interest in claims. So even if you're getting people into the insurance business, it's not necessarily going to be in claims. And people asked him, he said, why would you want to go into claims? I mean, there's brokering and underwriting and risk management and just so many things you can do within insurance. So first you have to get people interested in insurance, and then we have to get them interested in claims. So it's a challenge. And one of the mistakes I think some companies make now is requiring that, that college degree. Great to have one, but I don't think you should limit it and disqualify people if they don't have it. Some of the best claims people and insurance people I worked with came right out of high school. I had, my boss at a large company who was the head of the underwriting department, who started her career out of high school typing insurance policies by hand on the type. She was in a typing pool, and she ended up running the entire, insurance department for a, billion-dollar company. So you don't want to limit yourself. I know some of the things Lynn mentioned and David mentioned, just getting creative to veterans groups. We hear so much about all these parents who have kids that come home from college, or maybe don't go to college, or come back from the military and move back in the basement. Well, there's a pool for you. If you hear somebody saying, oh, my son or daughter's home, they're looking for something to do, but tell them they ought to think about insurance. That's what I did with my own nephew. He got out of college. He was working in health clubs and didn't know what to do. And I said, well, I can get you in actually clearing new underwriting submissions. That's where you're starting. He's now the head of a major wholesaler and is an expert in cyber and AI. So there's great opportunity. I think it's just a matter of reaching people, and we have to look anywhere and everywhere for this talent pool. And it's a bit of a crisis. I mean, our time is running on, the people who are doing the bulk of the claims handling now. So it is something we have to pay a lot of attention to.
Yeah, at Reuters, actually, 2 weeks ago, Reuters Chicago, I did exactly the same. There was a young attendee who wanted to do cyber. And I said, you have so much opportunity with cyber and insurance. You are going to have a great time. But actually coming to you, Alan, right? And we just talked about removal of college degrees. And I've seen this at Zurich, having been, involved with innovation at Zurich for a long time, over 7 years. So how have you been able to differentiate yourself, right? When you actually attract talent and build your talent pipeline? Here we are talking about claims management.
Yeah, we have a number of talent pipeline programs that we have been fostering. So just to name a couple, the apprenticeship program is something we brought over from Switzerland. really working with high school graduates who, want to do a hybrid of working as well as attending classes. So that gets them an associate's degree. We have a claims training program. Just this week, we graduated a group from last year, and we had a new group, a new cohort that just started about a week ago. So a number of talent pipeline programs that we have. But I think what's also important, and we talked about, the universities and colleges that offer these insurance programs, and I agree, they're fantastic. We'd love to get people from those programs. It is a challenge, as Dale said, not all of them want claims. So, how do we highlight what's interesting about the claim department? But what we've done also is eliminate that college education requirement as part of our recruitment process. And, the reason is we really want to focus on good experience. There's a number of people out there who have been either in the insurance business or related business for a number of years, and they bring a wealth of experience. And so as that person has more experience, the reliance on the college education and the college or associate's degree becomes less and less important. And we've had some really good luck with that. People who may not have had that college experience, but because they've worked in either insurance or another industry that's related, they come to us with a lot of experience. And so I think it's important to be creative when you're thinking about this. So look at what's really important when we're adjusting claims, right? We want people who are good with customer service. So think of all those customer service industries that are out there, right? And someone who's really excelled at that, and it naturally has a great way with customers and understands what that customer experience feels like, because that's extremely important to part of the claim handling process, right? But also having a natural curiosity, right? Some might call it skepticism, but we'll call it natural curiosity out there. And an eye for detail, right? If you think about it at its core, those are some really key aspects of having, I think, a good claim professional. So, we focus on our talent pipeline, the people coming into the organization. We do focus on retention as well, keeping the adjusters interested, not only in the claim handling they're doing, but our development programs. We focus a lot at Zurich on individual development plans, development programs, career counseling, career programs. So people feel that that there are opportunities out there for them to expand their knowledge, expand their experience, if that's what they want, right? So there's a number of ways I think we as an industry can really look at this to open it up to a lot more people who I think would really excel at claim handling.
Yeah, as you're actually speaking, Alan, I remember me 20 years ago. Don't look at my age, but I actually used to literally redefine claims processes 20 years ago. And one thing I learned when I did those from a technology viewpoint, looking at fraud detection, you have to be highly curious, but also very investigative, really understanding the pain points in a process from the insurance viewpoint, but also from the customer viewpoint, so that you can actually align the experience, because the customer wants one claim, so for, but on the other side, the insurers want to make sure it's true, it's correct, and, want to pay for sure the claims, but want to make sure it's done in the right way. So
Well, especially in the commercial sector, right? These are
yeah,
sophisticated customers who understand claims, they understand litigation, they understand social inflation, and certainly what those drivers are, especially now that we've really been educating them on that. So we need claim handlers and claim professionals who can speak that language, right, and who can understand what that level of customer is looking for.
yeah. And before going into the I question, Dale, there's a question for you. Dale, you mentioned the challenge of retiring claims professional. What do you see, technology or artificial intelligence? We know we are going to go into that AI discussion. Role is helping increase the capacity of your claims team without having to increase the number of people. So let's go into the technology question now. Let's start with you, Dale.
That's a great question. And I think Lynn mentioned it. I mean, AI is definitely going to be a tool, and definitely, I've been talking about with some of these smaller companies that just are stretched. A lot of, again, our farm and agricultural writers with things like derechos and the F5 tornadoes, they're getting just inundated with claims. And you have to be efficient. So if you can use that AI tool, for example, one on intake. I mean, I know that sometimes, especially in smaller companies, people are used to calling up and talking to a person to report their claim, but that may not be as efficient as being able to get in and just report your claim either by text, email, or on the phone, and then it gets routed. And if there's AI, they can triage those claims to ones that need, immediate or severity, or can get your most claims people attached to your most serious claims without taking the time to go through everything. That's going to be a key tool. Now, you can't, I think, as Lynn also mentioned, rely on AI to do the claims work. You're going to have a problem if you go there. So you still need people looking at it, but the AI can certainly do the more mundane tasks and make the claim department more efficient in general. Also, I mean, we have little mutual companies that are still doing things, by fax, don't have the most quick or up-to-date computers or claim. The claim systems sometimes go back to the 80s. Sometimes they're unreliable. All this slows you down. So just being able to get the right technology, use the AI, and make your people as efficient as possible is going to help a lot. Because like I said, you're pulled at both ends. You're getting more and more claims. You have possibly less people to handle them. And at some point, there's a breaking point. So I think this is just a key issue with all insurers, but especially with, in the claim departments of our smaller mutuals.
Yeah, and that makes me remember to ask you, Dale, right, when you start looking at artificial intelligence, and I was trying to find one of these posts I was sent very early this morning. The CEO of ChatGPT is surprised that people trust ChatGPT. So that is one of the message I received at 6 o'clock this morning. So when you start looking at how can smaller insurers leverage technology to compete with larger players, what do you see is the role of AI there?
I can just give you an example, Sabine, that in handling your claim using AI, you can get to the crux of the matter. I'll just give you a quick example. We had a claim come in, and it is an insurance agent's claim, but the underlying matter is medical malpractice. And it was a kind of a complicated issue involving the role of a pathologist. But I was able to go just into Google AI and ask a question regarding the potential liability of this pathologist, and it gives you an answer. Now, it doesn't give you a lot of citation to anything, but I could get on and get the right counsel and send the information I had to that counsel and say, here's where I think we're going with this. Can you tell me if I'm on the right path? Is this one where we're not really looking at liability, or do I have a problem here? So you can kind of get a start on your claims, get a handle on where maybe the initial reserve should be, and something that would have taken, maybe a day or two of research, you can do in 5 or 10 minutes. And maybe you can handle some claims without, as we all know, getting counsel involved. If smaller claims, if you have to send everything out to counsel, it's expensive. You're going to pay. So if you can have your claims people get these claims resolved, maybe pre-litigation, with the help of doing some research using the AI that doesn't take them a lot of time, then you can cut down your costs. You can close your claims quicker, and just be more efficient in general using AI as a tool. Now, again, as we've said, don't take it as the final word. Don't trust it completely. You need to get some backup, but it can definitely get you started in the right direction.
Yeah, and I think the key word is to get you started in the right direction. Sorry, Lynn. I think it is important, right? It's about augmentation.
Yeah, and I think it does, it accelerates some of those administrative matters that were dragging folks down. And when we think about what's that next generation claims professional look like, they're used to technology. The rate of adoption of technology, even with, let's say us more seasoned professionals, we are using ChatGPT to plan our vacation, or to find new restaurants, and whether it's Instagram or whatever, we're definitely more into that social media. and that ramp up of quick turnaround time on ease of access to information. And that allows us that freedom to do that deeper dive, to take on more of that higher level of work, of resolution. And, I believe, Alan, you mentioned basically the true core capabilities that we need in claims professionals. And that, it may be a different way of training. Maybe they're not, progressing through FNOL and through the call center and then becoming a trainee and going through that typical training program, but they're going to come in with, that customer experience skill set, perhaps that ability to negotiate, the ability to empathize, and to find that proper resolution more quickly, and just using those tools to take away that noise that was slowing them down. And I think that's how we look at it. And I think it's just interesting that we're talking about sort of that self-reflection and talent when we're talking about such a sort of on the opposite end, that social inflation and those nuclear verdicts.
Yeah, maybe I can ask you to maybe dive into that question, right? Because you already talked about, the power of AI as long as it's guided, right? And as long as we are using it as a way to augment our work, because at the end of the day, there is AI hallucination. Legal counsel is saying there is a risk of using artificial intelligence. So can we discuss perhaps the bumpers and a guardrail we should see here? Any ideas to how we actually contain that?
Well, I think, again, how are we using it? If you're using it to do the legal research and write the brief, buyer beware. You're doing that at your own peril. And that is not anything I would ever suggest. However, if you have a template, a communication, if there are a volume of documents and you want a summary of that, it may at least get you into it and focus your attention on a particular area. And then as you have more information, again, it can help guide your curiosity. And we've talked a lot about curiosity today. And I think it just heightens it. It allows you to have that freedom to think and to use the arguments that perhaps, again, bring you to the resolution. That is what we're here to do. A claim comes in, we need to evaluate it and resolve it. That is our job. And how we do that and the tools we use are just critical. If you think back on how we used to do legal research, right? You went into the books, you shepherdized it, and you needed to understand that before you went to a Westlaw or a Lexis or other type of database to search your cases, because otherwise you would have missed something. And we just need to make sure that when we use the technology, we're not replacing our intellect. We actually understand what it's giving back to us when the information doesn't quite look right and how we have to then correct it. We just can't trust it on its face at all.
Yeah, what I've done is I gave a name to my virtual assistant, to my chat GPT, and I will ask it question. Let's say, last night I asked question, and then I sit on it, and then I do more research to actually find, the perfect answer. Anyhow, I want to come to Alan and David, because I think that question, which I sat on for quite a while, is for you both. And I will start with David and then come to Alan. So the plaintiff bar use excessive AI technology, I hear, right, to share data. Why are we reluctant to do the same on the defense side? And I had a defense question for Alan. So I think we can actually mix that up, right? When you start looking at high risk claims and, when we start looking at defense attorney activities. So starting with you, David.
Sure. Yeah, no, it's really interesting. It kind of builds on some of the comments, Lynn was making as well. So yeah, and Alan had shared this earlier, that the plaintiff's bar has been very good at, sharing strategies, tactics, reptile theory, that sort of thing, and kind of, training one another. And on the defense side, it's been, much less so. I think, in large part, because the industry itself, the insurance industry, goes without saying, is a risk-averse industry. And there's, broader concerns about, disclosing too much, or perhaps, running afoul of any kind of like privacy or confidentiality, concerns, things of that particular nature. But kind of, touching on those AI tools, it's, there are some companies out there that plaintiffs' firms are currently utilizing that, for example, spin up using generative AI to build medical demand packages that are 1,000 pages long, 1,500 pages long. And then they're sending those, over to the carriers and the defense counsel to ingest. And the broader question is, well, is the industry going to utilize some type of generative AI to summarize, that information or identify kind of the key items, within that. And it's almost like an arms race, at this point, on that particular front. And to the person who asked the question about some of the attorneys and the firms commenting that the use by the claims teams within the insurance industry, that there's a, it's risky. Of course, it's risky, but the law firm should also look in the mirror a little bit. There's plenty of cases out there right now of firms that have utilized open source systems like ChatGPT to help draft their briefs, which came up with fake citations. There's countless stories of that at this particular juncture. Again, I think it's a matter of using such tools properly to augment the decision-making process, summarizing large amounts of information, and the firms themselves, they have tools as well. There are tools that allow folks to create deposition outlines, build chronologies. Especially on the chronologies, those are one of the tools on the claim side of the house that's very helpful. Basically, scraping through all of your documents and amongst different documents and pulling together what a timeline looks like of the events that transpired on a particular matter. So again, to Dale's earlier point, you got to double check it. You got to go back to the source and verify things, but at least it gives you a really good starting point there.
Yeah, before going to Alan, let's remember that AI hallucination is often caused because the AI doesn't really understand the question. So language needs to be highly accurate. And today, most of the insurers I speak with have what I call private GPT. So I would assume Dale as, Dell GPT, Alan as Zurich GPT. Most insurers I speak to have a GPT on top of their internal knowledge base. And I think a lot of people are still scared to interrogate the internal knowledge which is out there. And so learning to use those tools and learning to ask the right question, I think, is going to be key right now for us to progress with the technology. Alan, same question to you, and maybe you may want to pick on some question we have on the side, but I would love to hear from you on that plaintiff bar question and how you see the evolution in defense attorney when you start looking at artificial intelligence, for instance.
Sure. No, and I'm glad you brought up the internal GPTs because we do have our own here. And it's a good reminder to everybody out there that anytime, if you put any private information or personal information into that chat GPT question, right, it has the potential for coming public, right? So we admonish our claims people, our defense attorneys, certainly not to do that, right? So we have a number of internal tools that we use, all for the efficiencies that I think the rest of the panel has really addressed properly. But in terms of litigation, right? So how does technology affect that, as I understand the question? So, one of the first things that comes to mind is jury selection. So there are a number of tools out there that do allow the defense attorney to do a deeper dive into the potential jurors they're looking at. Very often during this jury selection process, there's limited information known, and you're making snap judgments about if this person is going to have some sort of corporate bias or what their background is that really going to affect the way they're going to rule or to decide in this case? But there's a number of tools out there that actually work in real time that do allow you as the defense attorney to have a little more insight into the publicly available information regarding that juror. So I think that's one way that the defense bar can really push back in terms of choosing that right jury, right? So the societal elements and drivers I talked about earlier can be addressed a little bit more in that jury selection process. But I also think, and this is something we've addressed at our defense attorney summit, the last one actually, was, what you really need to do is tell a good story to make the complex simple. We know our case in and out. The plaintiff side knows their case in and out, but a jury has a very limited view of it, right? So how do you take that complexity and make it simple? So one way that we highlighted was through accident construction. This is a field that has advanced a lot over the last several years. We use an example of product liability case against a car manufacturer for an airbag deployment, and they recreated the entire accident. I mean, at some cost for sure, but it really gave the jury a view into exactly what the defense was to this case. I will say it was, I think the demand, what they asked of the jury was $42 million, and it came out as a defense verdict. So the accident construction, despite the cost, was certainly worth it because it allowed the jury just to see. And I think jurors these days expect that, right? They're so used to chat GPT, they're so used to their phones, they're so used to all of this data and information just being readily available that they're looking for something visual here. So by being able to demonstrate that, I think the defense attorneys in that case did a fantastic job of defending the case, but also letting the juries know this is what our defense is and this is why. So I'm just a huge proponent of that, as well as the mock trials, right? So mock trials years ago used to be a very expensive proposition, but because of Zoom and Teams and all these other, various tools, a number of jury service organizations have been able to streamline that process, right? They're smaller, sort of skinny down mock trials, which I think are a great tool for defense, as I talked about earlier, to be more objective about their case, get a small group in, give them the closing arguments, and let's see what they say about it. So yes, technology has got to be an important part about how we're defending these cases and combating social inflation.
Yeah, we have a few moments. I would love to speak about this forever because I think that is such an interesting topic. Actually, claim is, I would say, sexy. Some people may be smiling right now. But Dale, we have a question here. Are there certain data points that should be looked at when we actually looking at those cases to allow a case to settle earlier than trial? I will start with you, and maybe I can answer the question to all of you before I start closing that discussion. Dale.
Yeah, a great question again. And one thing we ask of all our counsel on the litigated claims is as soon as there's enough information, we want a liability and damage analysis, what the litigation plan is, and a budget. So we have a roadmap going forward. And the first thing I'd say, go back to the case we talked about earlier that got out of control, is on cases where there is clear liability. That's a point where you need to think you need to get this settled, because then you're just talking about damages, and damages can get very technical. You get your experts in, and especially where there's certain severe injuries, burn injuries, or something the jury can relate to, they kind of get lost in the damages. And where there's clear liability, a lot of times they will, if they're going to err, it's going to be on the side of the plaintiff. And we talked a little bit before about a couple of things. One is the reptile theory. I think David mentioned when, in the case again, when a part flies off a truck and hits someone coming the other way, that could have happened to anyone. And that's what the plaintiff's attorneys get across. It's you're not just deciding this one case, you're preventing this from happening to maybe you next time. And then the plaintiff's lawyers are also very good at anchoring the amount of damages. So they'll ask for a lot. And in one of the cases we had, they got about half, which was still millions of dollars. And when our defense counsel, underlying defense counsel for our insured, said, I thought this case was going in great, I was doing such a good job. And the jury said, oh, you did a great job. That's why we gave them half what they asked for. And it was a complete shock. So you have to address that. So where you have that combination of very adverse liability, you have damages that are really subject to a wide range. That's a point you have to make that decision. If it's a case that can't be tried, I think maybe David mentioned earlier, or maybe Alan, that you don't want counsel coming to you, which has probably happened to all of us in claims, and say, right before trial, I'm really not comfortable trying this one in Dallas County, Texas. It's like, well, you could have told me that, at a different point. It's been in the same jurisdiction this whole time. So you have to evaluate those points, the liability, potential damages, how reptile theory is going to work, the extent of the injury. Is it, something very physical, something that a jury can relate to, and then get that into some type of mediation as soon as you have sufficient information.
Yeah. So let's close this discussion because we're on time. And I will ask you one single question to you all to actually help our listeners to actually start taking some recommendation and actions to improve their claims litigation. So simple question: what transformative change or an innovation, a recommendation you believe will redefine how insurance combats social inflation and manage litigation? Starting with you, Lynn.
I would say just recognize the game's changed and we have to change. And that means control what you can control. And the 2 points that I've been harping on for the last hour, which is honest internal assessment, and that requires an investment in your team.
Yeah. Dale?
One thing that will be transformative that we do a lot at NAMIC is get involved in legislation, both at the state and federal level, and try and impact this legislation that goes against the industry right now, that's causing so much hardship. We've been really lumped in kind of with health insurance, which is so volatile right now. So we have to distinguish ourselves. And we have to get a handle on things like litigation funding, which is a whole nother discussion we could have, that's driving class action litigation. And we are working really hard right now in the legislatures to get some parameters and rules around that, because that's been a game changer for the plaintiff side. And we do have to fight back by influencing legislation wherever we can to make it more favorable to the insurance industry.
Yeah. Alan?
Yeah, I think it's all about tort reform. I mean, I agree with what everyone else has said here, but eliminating the anchoring we've talked about, eliminating these arbitrary values that are thrown out, limiting liability theories to what could be reasonably foreseeable. This is how we create long-term sustainable change in the industry, and advocating for that is actually key. We kicked off an industry coalition several years ago of insurers and other carriers and brokers and our customers as well, just to align and get together and focus on tort reform specifically. You know, since then, Florida passed tort reform, as David said, so did Georgia, and we're seeing some real momentum there. So I would say to everybody out there, you know, join that bandwagon and let's get on board, because I think now's the time and the momentum is there. And I think a lot of other legislators are looking at this. A lot of governors are. And if they want to, you know, regulate in sort of their insurance market, then they should be looking at tort reform as a way to level that playing field.
And David?
Yeah, just kind of building on the comments of my fellow panelists. You know, Lynn, I love your comment. Control what you can control, right? You know, basically invest in your people, build the right, you know, claim operating model and claims teams to be able to, you know, take advantage of, you know, new technologies like AI to really help, you know, supplement that in partnership. I mean, with the defense firms too. You know, the nature of firms are changing as well internally. You know, there's, you know, less graduates coming out of law school, you know, less attorney, they're getting more seasoned as well. So there's going to be, you know, some changes, and that interface, you know, between the two, I think is important. And then the long-term strategy that you can't control, but you can at least potentially influence, to Alan's point, is the tort reform that's, you know, picking up some steam, it appears, at least throughout some parts of the country currently. And, you know, any further momentum, I think, would be incredible.
Well, thank you to you all. I mean, as we conclude today's discussion on proactive claims litigation management, it's clear that success in today's environment requires a multifaceted approach. And I think the insights that Lynn, Dale, Alan, David shared today are really important to leveraging new ways of doing things, right? We talk a lot about artificial intelligence, but at the end of the day, it's about training our employees and adopting new innovation to actually do things better, faster. With the reinsurance crisis affecting small insurers and the continued evolution of planting strategy, the need for proactive management is clear. And so we encourage you to implement the strategy we talked about during our discussion, because there are so much we can do to do things better and achieve the right outcome. I hope to see you all at Reuters event, Connected Claim, in November in Orlando. And you know what? We have a wonderful format now where all our speakers attending the conference, and hopefully I will be still facilitating more conversation with all four of you, will be able to go on out of stage and do some roundtables to actually answer your one-to-one question. Because I can see a lot of questions here we didn't answer, but other guests, come to us in Orlando and you will see we are going to get many of those questions answered. So thank you, Lynn, Dale, Alan, and David, for this wonderful discussion. I look forward to seeing you all soon.
Thank you.
Thank you, everybody.